Employee rights, protection, and labor unions. Fair employment as a part of basic human rights. Human rights are the inalienable property of all human beings, without distinction based on nationality, place of residence, sex, national or ethnic origin, color, religion, language, or any other aspect. Collins shows that all organizations must respect human rights throughout their value chains, regardless of the ability or willingness of public authorities to protect these rights. Corporate responsibility for respecting human rights implies the obligation of organizations to prevent violations of them and to take into account the negative consequences of the observance of human rights to which they relate. The basic principles on which industrial relations are built come from human rights, such as the rights to life, freedom, privacy, health, and private property. According to Valentine et al., many mechanisms have been created in labor legislation that protect employees' rights as a result of the long-standing struggles of workers. The fact that the law protects fundamental human rights at work shows that workers typically prevail over employers in court. However, human rights violations continue to be expected, and employees only sometimes have access to the legal system. All employers must align their corporate values with their employees. The right of workers to form unions and their capacity to engage in collective bargaining through a group that advocates for them are significant in and of themselves. It is a right that suggests other potential outcomes, meaning that many other labor rights may be observed in conjunction with it. Fair employment conditions are the primary basis for the observance of other labor rights of workers and contribute to their awareness of their rights in general. Modern forms of slavery, including forced, indentured, or bonded labor and human trafficking, are strictly prohibited. Employees must be informed about the conditions of their employment and understand them. In addition, they should receive such information in a written contract that sets out their job's main terms and conditions in a language they can understand. The rights of workers connected to human rights include wages, hours of work, and employee benefits. Salary payments must be reasonable and by any applicable legal or regulatory requirements. Working hours must adhere to current legal requirements. Unless otherwise permitted by law or agreed upon through other lawful means, such as collective bargaining agreements, overtime work must be voluntary. Wage deductions are not allowed as a disciplinary measure. The employer's obligation under the law to respect human rights is to prohibit all forms of discrimination. It is forbidden to use corporal punishment, physical or verbal abuse, bullying, other types of illegal harassment, threats, or other forms of intimidation. Any form of prejudice-based discrimination is prohibited, including that based on racial or ethnic origin, gender, sexual orientation, political beliefs, or any other factor that cannot be used to limit one's rights or freedoms. To conclude, human rights directly impact labor laws, and employees have fought hard to reach their current position. Employers continue to develop methods to abuse workers' rights and take advantage of them. Every business is responsible for defending all its workers' human rights. Employees need to be aware of what protection mechanisms they have, and it is also essential that there are trade unions that workers can turn to. Unions in the United States, union management relations. Trade unions work to address the demands and worries of their members through the signing of collective agreements as well as the delivery of technical and related services. Labor unions provide extensive health and safety programs for their members. Trade unions and their members attempt to exert pressure on officials at the national and international levels, which is particularly visible in the adoption of health and safety laws meant to protect workers. The development of collective agreements, which formally formalize obligations in the area of safety and health, involves negotiations with employers and participation from trade union representatives. Numerous trade unions in the U.S. represent the nation's employees. According to Valentine et al., craft union members perform one job, frequently using specific knowledge and training. An industrial union comprises numerous people, regardless of their occupations, who work for the same business or industry. Workers can protect their rights through a network of trade unions at the federal level and inside each company. Trade union representatives can use the information gathered from such investigations by engaging in collective bargaining with the employer to resolve health and safety complaints. Workers can use the appeals process or provisions specifically spelled out in the contract for health and safety to protect their interests. The union may turn to federal regulatory or comparable state agencies for assistance if the employer is not abiding by established laws, rules, or regulations. Trade unions work to persuade lawmakers to propose legislation that sets reasonable health and safety standards. They influence how the government enacts workplace health and safety laws and organize support for the executive branch if the U.S. Congress imposes budget cuts or other operational changes. In conclusion, trade unions are the body that workers can use for full participation in this process. With the support of unions, every employee has a fair chance to participate in the formulation of rules actively. Labor unions perform their controlling role by acting as authorized public controllers on matters such as labor protection and working conditions, pay and labor rationing, social guarantees, and others.